お待たせをいたしました。改めまして、ブロックチェーンの健全な発展と新しいビジネス創造のためにご視聴いただきまして誠にありがとうございます。
Thank you very much for joining us for this
お時間
session.
となりましたので、これより
It is now time. We would like to start the next session entitled Blockchain and Data Protection. This is going to be a relay presentation. Without further ado, I would like to hand it over to Partner Attorney at Law at Nishimura and Asahi, Mr. Naoya Ariyoshi, to moderate the session. Mr. Ariyoshi, please. Good afternoon, ladies and gentlemen. Thank you very much for joining us for this session, the session on blockchain and data protection. I will be serving as the moderator for this session. I'm an attorney at law at Nishimura and Asahi. Now, when you think about the use of blockchain, one of the important points is data and information protection, increasing availability and usability. Information and data, especially in handling information, personal information, there are complicated regulations that are being applied. So in using blockchain, various regulations must be understood. And based on the deep understanding of the regulation, we need to work on data protection. Now in this session, use of blockchain. I do hope that this is going to be helpful in understanding that. So use of blockchain and data protection is the topic that we will be handling. Overseas discussions that have regulations advancing would like to discuss that. And the attorneys at law from Nishimura and Asahi will provide our commentary. Now, Japan, EU, and in the United States, what are the discussions progressing? Mostly on the Japanese situation, we'll have Mr. Yamamoto, and as for EU and the United States, Ms. Tsuda, attorney at law, will provide commentary. Now, in the financial area, the usage of blockchain will be discussed. With respect to Personal Information Protection Act as well as Customer Information Protection, Mr. Motoyanagi will provide commentary. Let us first start with Mr. Yamamoto with respect to the Personal Information Protection Act. My name is Yamamoto from Nishimura and Asahi. Today, for the first 20 to 25 minutes, I will be joined by Ms. Tsuda to talk about Personal Information Protection Act in Japan. Now, these things I'm sure you're quite familiar with. Some of the notable features of blockchain is that it's difficult to change, that is, it's immutable and it's available. It's a database that is highly available. These are some of the features of blockchain. Now, practical use cases include recording financial transactions, recording contracts, and storing personal information. These are some of the uses. Of course, these are matters for the system, but in using blockchain, when you have nodes across borders, in terms of personal information protection, there will be legal problems. So in Japan, we have Personal Information Protection Act, whether that will be applied or not, or GDPR of the EU, how is that going to be applied? Those are some of the things that we would like to discuss today. Now, we mentioned here on the screen, there are discussions advancing in Europe, but in Japan and the US, discussions have not progressed as much. So we would like to provide some information that may be relevant to future discussions. Now, some of the assumptions of our discussion today. Today, in order to make our discussion easy to understand or bring them in relief, we are assuming a public type blockchain in having our discussion today. Now, for this table, This is just a general classification of blockchains. There's public type, where there is no administrator, free to participate. Viewing the ledger, there are no limits. As for consensus algorithm, proof of work is being used, and there is mining compensation to be paid, and transaction processing, depending on how it is set up, it relatively takes a longer time. These are some of the notable features about the public type blockchain. Now, over on the right-hand side, compared to the consortium type and private type, these are some of the differences of a public type blockchain. Now, in order to bring into relief the discussion, these are some of the notable features of public blockchains. There are 4 points. One is that there is no administrator. The second point, obviously, this depends on the design, but nodes exist across borders. And number 3, transaction records are shared and made public. Number 4, 51% attacks do exist, but there is practically no possibility to change. It is immutable. So in terms of the mechanism of Bitcoin, this is considered as useful. But in relation to Personal Information Protection Act, there could be some conflicts and inconsistencies. So starting in the European Union, there are discussions underway. First, this is discussion in Japan. Now, Personal Information Protection Act, and when personal information is stored on blockchain, why is there a conflict? Basically, Personal Information Protection Act is assuming an operator who collects and uses personal information in a centralized way, and regulations are applied. So this is in conflict with public blockchains. Of course, if this is going to be considered illegal or not depends on individual use case. But we need to give deliberation and discussion over this point. Now, whether this falls under personal information, whether this operator falls under personal information handling operator, needs to be considered. And based on Personal Information Protection Act, there could be conflict with the regulations as well as ways to avoid and work around these regulations. We would delve further into detail about these matters later on. First, whether it falls under personal information. Things that are not considered personal information, when such information is stored, then obviously that's not personal information, but names, date of birth, or other information. By collating with other information, if you are able to identify an individual, then they would fall under personal information under the law. Now, what is oftentimes discussed is when it's coded and encrypted, that may not fall under personal information. So even if it is on blockchain, these problems could be worked around through encryption. That is oftentimes discussed. But according to the Commission's guidelines, through encryption, whether it is kept secret or not, is not a consideration. Just because it is encrypted, you cannot say that that's not personal information. But by hashing it, irreversible change in information to make it unidentifiable, whether that is possible or not, is being discussed. Another point, personal information handling business operator. As long as you're not considered an operator, the law will not be applied. But unfortunately, even if it is non-profit, you could fall under a business. This is according to the Commission's guidelines. But if it is for an academic purpose or a node that is set up through technical interest, whether personal information obligation should be applied is a matter for discussion. But when you think about this, all nodes, there is the possibility that all nodes will be considered operators, but public blockchain, people who are really engaging in business with that interest is a question. And when you have node that is anonymous, then we have to, there's discussion underway whether there is a good way around.
And coming to the third point, apart from the person responsible or the leader, it could be regarded outside of the scope of a personal information handling business operator. That is one interpretation. Furthermore, in greater detail, if we assume that information is regarded as personal information and is also regarded as a personal information handling business operator, it will be subject to various restrictions. And there are 4 points that are characteristic of a public type blockchain that come into clash. Not being able to delete or correct or amend. That is one thing that will be in conflict with Article 19. Or the distributed nature of blockchain. They say there is a centralized entity and some organization beyond that. Instead, if there is a more horizontal relationship, how could we capture or look at the personal information? Those are some issues. And of course, these are things that may arise, but is it really impossible to correct or delete? Is everyone truly on an equal footing? That depends on the way business is used, and also the public type that I referred to earlier refers to some extreme case, and there, in reality, a private type or consortium type might be more frequently seen. Maybe those types could be effectively used and compensate with technology. And that kind of business, I think, could be sought in light of Personal Information Protection Act. This involves more specialized information, but under the Personal Information Protection Act in Japan, personal data, when that is provided to a third party, will need to obtain in advance the person's consent. Whether this will be regarded as third-party provision, there's discussion on that. But if there is no consent, opt-out, or entrusting, or joint utilization are available. And I don't intend to say that this is an exhaustive discussion, but taking the example of consent, for example, if there are so many nodes, it's not evident to how much information is spread, and therefore we don't even know how to get the consent and who will be defined as a third party. And in the case of entrusting, in the distributed structure, a person entrusting to another person, will that be able to be clarified from a legislative perspective? And also certain items need to be identified under joint utilization. Under a public type blockchain, will this be truly functionable in reality? These are items and aspects that need to be checked and identified. That is all from me for now. Mr. Yamamoto, attorney at law, thank you very much for that. In thinking about the Personal Information Protection Act in Japan, we need to take into account the features of a blockchain and need to assert some discussions in light of that. Ms. Tsuda will now talk about some issues regarding discussions in EU and the United States. This is Tsuda speaking, and I would like to share with you discussions that are taking place in the EU and in the United States. First of all, with regards to discussions in the EU, compared to Japan, they have discussions that are ongoing and ahead of Japan in formulated commissions. For example, the Article 29 Working Party. Members of the EU and regulators in each of the EU member states will come together under this. And there's also a European Union Blockchain Observatory. And in other member countries, in France, they are well advanced in terms of their discussions on personal information protection, and they are quite active on this front. At Max Planck's, Dr. Michel Fink, when GDPR was introduced in the EU, published various literature, articles, and actively engaged in the discussion of personal information protection. And one symbolic movement is that the European Commission 2020 strategy, a European strategy for data, has been put together where blockchain was referred. I think it's fair to say that blockchain is attracting a lot of attention amongst the members of the EU. Personal information protection legislation that will be applied across the EU is GDPR, General Data Protection Regulation. There are some tense situation regarding GDPR in a blockchain. And some basic facts about GDPR is, as written here, it was put together and enforced from May 25th of 2018 in place of an existing regulation. And the structure is quite similar to the Personal Information Protection Act in Japan. The challenges of blockchain under GDPR is whether blockchain needs to think that GDPR will be applied to blockchain. And in conclusion, I would say that in the world of blockchain, the discussion of GDPR application cannot be avoided. And what I mean by that is that the GDPR does not require offices or representative offices within the European Union. Extraterritorial application could be done. For example, for individuals who reside within the EU, personal information will be covered under GDPR. And as mentioned in this slide, for individuals who live outside EEA, any provision of services or products to them, and also anything that pertains to the monitoring of behavior of individuals that reside outside of the EEA will also be subject to the extraterritorial application of GDPR. And therefore, the subject of GDPR, whether blockchain will regard the personal information, and the controller, whether blockchain participants will be regarded as controller. If these two tests are met, you would need to comply with the GDPR regulation, otherwise it will be in violation of it. But as I said, there's a sense of tenseness with GDPR, but the structure of GDPR and blockchain are in conflict with one another. There is, however, not only a negative aspect to this, because the robust structure of GDPR could be appreciated, and discussion is way ahead, and therefore there are some positive aspects that are underpinned as well. Let me start with personal data, individual data. GDPR definition is that any information related to identified or unidentifiable natural persons is regarded as individual or personal information. Under plain text or encrypted or hashed, various formats could be used on the blockchain for personal information, and all these aspects, all of them could be regarded as personal data. This is the discussion taking place in EU. But if When hashing is used, there are diverse ways of hashing, and depending on the method adopted, it could be regarded as not applicable to personal data. The French regulators talks about the reversal risk of hashing and using of keyed hashtags.
And personal information, in order to get exemption from GDPR application, whether hashing is possible to make it anonymous. This is also being discussed. Hashing method and standards to design it so that it will not be considered personal information, to be exempted from GDPR, to be placed outside of GDPR's scope. That is also some discussion that are underway. Another important discussion point, data controller or administrator. The purpose of handling of personal data, as well as deciding the direction of such handling. That is the definition of data controller, whether you fall under this controller or not. Earlier, there are 3 types of blockchains discussed. In public blockchain, this could be a problem. In public blockchain, problems are notable because developer, nodes, miners, all these rights are distributed. So data controller, whether that could be conceptualized or not, is the focus of discussion. In GDPR, data controller collects, administers, and processes data. This is a centralized figure. That's the assumption. So the mechanism of blockchain are not so compatible. There could be some difficulty in interpreting this. Of the players who could become a controller, that is a discussion point, which is the biggest. Let us look at them in sequence. For developers, basically, they would not fall under the definition of a controller because personal data handling purpose for each developer, it could be varied. So any certain purpose is not defined. Now next, nodes. Nodes could be close to being a controller the most. That is how it is being discussed. But nodes themselves, their existence is not equivalent to a controller. So that is some of the discussion that are being played out in some literature and discussions. Depending on the scheme of each blockchain, you cannot definitively say that nodes always fall under the definition of a controller. Miners, obviously, they do not fall under the definition of a controller. That is how discussion is conducted, because they only do mining. So they're not in a position to decide on the purpose or method of handling personal data. Other GDPR-related discussions include these points on the slide. Let me start from the top. In Japan, in Personal Information Protection Act, similar discussions are underway. Data principle, personal information, the person whose personal information is relevant here. The person has the right to ask for correction or right to be forgotten. But there's the problem of data not being able to be deleted on blocks. So there could be some conflict here. Destruction of decryption key could be considered the right to be forgotten, and by making use of off-chains, deletion could be conceptualized. So that is according to some analysis. Now, next point. This is similar to the right to be forgotten. The period of storage. On GDPR, period of storage must be decided. So some data that will be stored perpetually is not being assumed in the first place. So there is also another problem here. Now, data protection impact assessment for handling of personal data with higher risk. This is an assessment to analyze and measure such risk. There is the awareness of issue, whether this has to be implemented or not. There are other matters as well. According to GDPR, the basis of applicability of data handling. For example, personal information can be processed if there is consent from the principal. But whether that consent has been obtained or not is another problem that does exist. So those are the discussions, the main discussion points in the European Union. Next, turning to the United States. What is the situation there? Similar to Japan, at formal discussion bodies, it's not still a situation where discussion is underway like the EU. At the federal level, there are no certain regulations with respect to blockchain. For cryptocurrencies, in order to have consistency between states, there are uniform set of rules and regulations that have been announced. Now, on the regulations on blockchain and virtual currencies, different states have different responses. For example, in New York, there is the licensing system for businesses that handle virtual currencies, and they have high requirements of standards for cybersecurity, privacy, and personal information protection. Security's importance is emphasized in the United States. So these are the situations in various countries and regions. Let me summarize. Personal Information Protection Act, or GDPR, how is it going to be applied to what kind of players? The direction of discussion is still not certain. But still, in designing various services, each participant could fall under applicability. And from the standpoint of compliance with laws and regulations, it's important to deal with these requirements. That is, for companies offering blockchain services based on hashing and other technology, privacy by design notion could be introduced, or privacy and personal information protection standards should be kept in mind in designing various services. That will become important. In order to avoid a situation where you will be considered illegal by adopting private blockchain or off blockchain or deleting past transaction records, such specific designs could be considered. But in the world of blockchain and the world of data protection, the philosophies are in conflict. So for those things that are where there are no concerns of illegality, we have to make sure that innovation would not be hindered. That is all from me. Thank you. Thank you very much, Ms. Tsuda. Europe has advanced discussions underway, and in thinking about Japanese Personal Information Protection Act, it provides a lot of reference and utilization of data on blockchain. EU and US regulations and their developments are something that we have to keep paying attention to. Next, turning to Mr. Motoyanagi to talk about the situation in the financial world. Handing it over to you, Mr. Motoyanagi, please. Thank you very much.
In my part, I would like to summarize some of the discussions that have taken already. And I will talk about financial institutions and the personal information and customer information. Starting with financial institution, the importance of blockchain technology is acknowledged, and the Mirai Investment Strategy 2017 Society 5.0 acknowledges the importance and the potential of blockchain. This is appreciated across different financial information, but the financial institutions have very robust and very strict regulations on personal information and customer information. There's the Banking Act and supervisory approaches, and there are guidelines on personal information protection in the financial industry. And there is also operational instructions of security management measures for the guideline, and also Q&As for personal information protection by financial institutions. These should be referred to. Before talking about blockchain, we need to be mindful of how financial institutions are positioned. It's basically the same thinking of Personal Information Act. We have the FIEA and also the Banking Act, structured in a similar way as the Personal Information Protection Act. But the scheme or organization needs to be set up, system set up obligation is on the part of the financial institutions, and the FSA, JFSA will monitor, supervise whether that scheme or system is in place. And if that obligation is not fulfilled, the regulatory authorities will have on-site inspections, and that could be followed by some obligations to follow rules and also rectify the situation. And next, when it comes to personal information and customer information, this is from the Banking Act. Banks shall appropriately handle customer information acquired in relation to its business, take measures to ensure sound and appropriate management. So this system has to be in place. And based on that, under the comprehensive guidelines for supervision of major banks, it stipulates that the customer information constitute the basis of financial transactions, and that the management of customer information is something that major banks or banks would need to adhere to. At the bottom of this slide, in light of blockchain, in relation to blockchain, as Mr. Yamamoto and Ms. Tsuda mentioned earlier, there are unique features of blockchain, which is centralized, where the banks are managing on its own. That forms the basis of the existing laws. But when it comes to distributed system, there are issues associated to the regulations of that. Ms. Tsuda already talked about the discussions in the EU, but I think this thinking is also very meaningful. This is the Article 9 of the guidelines for protection of personal information in the finance sector. Business operators should set up a certain period of time after the termination of the contract and should delete personal data after the lapse of that determined retention period. As mentioned earlier, this not putting it on the blockchain, giving it off-chain or deleting the encryption key, those are two ideas that we could think of. Going off-chain, the question is whether that will be workable. Management of personal information and customer information in light of that, managing offline, will that be useful? Will that work? That is a question. And the deletion of encryption key, will that mean deletion of personal information? Will that fall under the definition of delete under Japanese law? That separate discussion than the EU discussion will need to take place in Japan. And another point which is not mentioned here is, again, under Article 9, within the scope that is required to achieve the use purpose, the personal information needs to be maintained, updated, latest, most updated and recent information, that would have an issue under the public type blockchain. The original thinking is that the banks would manage this as a ledger, and therefore the renewal obligation felt with the banking institutions. But under a public blockchain, it depends on the design, but the banks will not have the ability to manage or control. They won't be able to correct even if they want, and therefore that would be in violation of Article 9, which requires banks to make effort to renew and keep up to date. And there's also another issue of outsourcing, entrusting the business to a third party, and this was briefly mentioned under EU discussion as well. Node participants, what would be their positions? Banks would need to store data appropriately, but most of the people taking part in the blockchain will be third-party nodes. So we would need to have discussions on how to define a third party. And if a third party is to be utilized, appropriate management will need to be in place. That is stipulated under the Banking Act, and the ordinance for enforcement of the Banking Act also provides for the use of third parties using hashing. To what extent will this be addressed? There are such discussions. Referring to the discussions taking place in the EU, we, I think, need to set up a right mechanism in Japan. But using hashing, could we claim that the third party is not used? That, I think, is one key point. And these are for banks, but in the same way, for using third parties, financial instruments operators and so forth will also fall under similar kind of discussions. And even if it's not the personal information, use of third parties, there are regulations under Banking Act, and so even if data is hashed and therefore entrusted to a third party, as long as a third party is used, this would need to be taken into account. And another point which may not be directly related to this is that there are standards that are set forth by the Center for Financial Industry Information Systems, FISC, and this was discussed. A very important discussion point was raised talking about the cloud services, and the similar kind of discussions will be required for blockchain technology. The way in which blockchain is used, what would be on-premise, and what will be blockchain? Similar discussion as cloud service, I think, will need to be seen. And that is all for me. Mr. Motoyanagi, thank you very much for that. So far we have heard from 3 attorneys at law, and as Mr. Motoyanagi mentioned, he talked about blockchain in financial institutions. The use of blockchain is raising excitement in non-financial areas as well, but blockchain involves a different way of thinking than conventional thinking, and therefore it could raise different types of discussions in personal information, use of personal information and customer information. And as I mentioned briefly earlier, internet has no borders, and therefore not just the regulations in Japan, but also regulations in the EU, the United States, and other parts of the world will also be taken into account, even if we are doing business only in Japan. And I hope that what we've shared with you today will be conducive to the development of blockchain technology going forward. And before closing, I want to briefly advertise what we do at Nishimura and Asahi. As you see on the slide, this is the encyclopedia of personal information protection law. This will be published very soon. It talks about a blockchain and takes up various discussion points on blockchain. We will be most happy if you could find your time and take a look at this book. Thank you very much for joining us today. And with this, we would like to close this session. Thank you very much. Thank you very much for the very valuable talk of Mr. Ariyoshi, Mr. Yamamoto, Ms. Tsuda, and Mr. Motoyanagi. Thank you very much. And with this, we would like to conclude this session, which was a relay presentation for blockchain and data protection. Next session will start from 2:15 at Hall A. It will be a panel discussion on will Japan's STO take off with Act revision? And in Hall B, keynote speech, Navigating the Future of a Distrusted Digital World, a primer for policymakers and global leaders. Those of you who will be joining us online, please select the URL of your choice and join us. Please bear with us for a few more minutes before we start the next session. Thank you.